All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning, all. Yes, Mr. Shimano, please call the docket.
First case on the 10:30 a.m. docket for Thursday, January 30th, 2025 is appeal number 128007 in the matter of Sean E. Stewart, original action and attorney discipline, briefs both sides.
Good morning, and may it please the court. The Office of the Disciplinary Administrator appears by Kate Duncan Butler. Also present today is my co-counsel Alice Walker, present and ready for argument.
Madam Chief Justice, your honors, may it please the court. The respondent appears in person by John Ambrosia, who represents him. We are ready for argument. He would also like to address the court after I finish my brief argument, with your permission.
Your permission granted.
Second case, appeal number 127949 in the matter of James L. Daniels, original action and attorney discipline, briefs both sides.
May it please the court, Amanda Voth on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
Good morning, your honors. May it please the court. Keith Cutler on behalf of respondent James L. Daniels, who also appears in person. Mr. Daniels would also like permission to address the court after counsel's remarks.
Permission granted. Thank
You,
you.
Your Honor.
Your Honor, that concludes our docket for the week of January 29th.
Thank you, Mr. Shima. We'll call 128007 in the matter of Sean Stewart. Ms. Butler?
Good morning, and may it please the court. Kate Duncan Butler appears this morning on behalf of the Office of the Disciplinary Administrator. Madam Chief Justice, I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving the respondent, Sean Stewart, who has been licensed to practice law in the state of Kansas since 2002. This matter comes before the court after an evidentiary hearing held on May 1st, 2024. Prior to the hearing, the parties stipulated to the operative facts underlying the case, as well as Mr. Stewart's violation of KRPC 8.4 subsection C, which is misconduct involving fraud, deceit, dishonesty, or misrepresentation. As such, the parties focused on evidence concerning the appropriate discipline at the hearing. The Office of the Disciplinary Administrator's theory of the case was that Mr. Stewart repeatedly violated KRPC 8.4C by providing information he knew to be false to the Kansas Department of Labor to apply for and maintain certain unemployment benefits during the COVID-19 pandemic. In the final hearing report, however, the hearing panel found that Mr. Stewart had only provided false information and therefore had only violated the rule a single time, and that act, which involved representations of his income, only constituted negligent misrepresentation and not intentional or knowing dishonesty, as our office had alleged. The hearing panel recommended a published censure. The Office of the Disciplinary Administrator filed exceptions to the final hearing report on August 23rd, 2024, objecting to many of the hearing panel's findings of fact regarding Mr. Stewart's conduct, his mental state, and the aggravating circumstances appropriate in this case. To summarize the facts that remain undisputed on appeal before I get into the specificities, of our argument, Mr. Stewart was a solo practitioner at the time involving this case, and he operated a law firm out of his home. His primary client had been a business client that he had done transactional work for and then later went on to represent in litigation. In 2019, the work in the federal litigation had largely turned to collecting the judgment from that litigation, and he and his client jointly converted their representation to a contingency fee matter. Mr. Stewart testified at the hearing that they did not really anticipate collecting. I believe he called it a futile endeavor, and stated that sort of around the time the COVID-19 pandemic arrived, work for that case had slowed down. In March 2020, as we are all well aware, the COVID-19 pandemic shut down many businesses and government entities. At that time, Mr. Stewart applied for unemployment. It was traditional unemployment, and because he was self-employed and did not have reportable wages, his application was denied. Later in May 2020, the federal government implemented new legislation that allowed for self-employed people to receive unemployment under a program called Pandemic Unemployment Assistance, or PUA. Mr. Stewart applied for that program shortly after it became available, stating on his application that he had become unemployed on February 29th, 2020. As part of that initial application, he had to fill out an income verification sheet that asked for his quarterly net income from 2019. Mr. Stewart represented that he made $30,000 net income each quarter, or a total net income of $120,000 in 2019. That was not accurate. He had not completed his 2019 taxes at the time, and while the $120,000 was close to, actually slightly less than his gross income from 2019, it was not accurate to his net income. Nevertheless, the Department of Labor approved Mr. Stewart, and he began receiving PUA unemployment benefits. To receive benefits under this program, each week, Mr. Stewart had to fill out a weekly claim form in which he had to provide the Department of Labor certain information. It was a sequence of check boxes that had to be filled out, many of which are in the record at Exhibit 11. Those check boxes, among other things, asked whether the claimant had worked or received income in traditional employment, or had worked in or received compensation for self-employment during the given week. With the exception of 1 week, Mr. Stewart indicated each week that he had neither worked nor received compensation in self-employment during that benefit week. He continued to fill out the forms throughout the benefit period, including during the period in which he had stopped receiving benefits because his benefits had been suspended due to the Department of Labor investigating him. The Department of Labor, at the end of the benefit period, after investigating Mr. Stewart's claims, found that he had committed fraud under their standards by either supplying false information, having another supply false information, or not submitting information to the department when asked. Mr. Stewart appealed this initial finding, but ultimately did not appear. The reason he did not appear was at that time he had been in contact with the Department of Labor trying to work out how to repay the benefits he had received. Nevertheless, the Department of Labor upheld the finding on a default on appeal because he did not appear, and submitted a complaint regarding his conduct to our office. At the heart of the appeal in this case.
Can I stop you right there? So there was never any evidence presented to the KDOL. Those were default judgments, right?
Correct. Mr. Stewart's conduct in filling out the forms, both the application for unemployment and the weekly benefit forms, are really at the heart of our issues on appeal. The hearing panel rejected 3 different instances that our office had alleged was dishonest. A representation he made about his business client on his initial employment application, and then his conduct in stating that he did not work in weeks he did, and stating that he did not receive compensation in weeks that he did. And so I would like to address each of those in turn. The initial on his initial unemployment application, Mr. Stewart filled out a blank that asked why is he unemployed? And he said because the COVID-19 pandemic had shut his only client down. The hearing panel reasoned that because the client had been closed down, and there's testimony in the record that Mr. Stewart learned his client had been closed down because of COVID-19, Mr. Stewart was not getting any work from that client, ergo that was the reason he was unemployed. First, it's important to note that the record does not reflect that Mr. Stewart was anticipating other work from that client apart from that matter that had been converted to contingency fee litigation. It is also not clear when, in relation to the pandemic, Mr. Stewart learned about the shutdown of his client. Nevertheless, what the record does reflect is that at the time Mr. Stewart made that representation, he had converted that representation of his client to a contingency fee matter. And by that, he was no longer expecting to receive regular compensation for that client. He was unemployed under that client, not because of COVID, but because he was doing contingency fee work and was not receiving payment for that. And in fact, he had testified that at the time he applied, nothing had happened on that case for a number of months. And-
Is the problem that it wasn't, there's no causation? Is that the issue? That the operations weren't closed by COVID? Or that that he represented that the operations had shut down? Because that sounds like not an inaccurate.
It was not inaccurate in a vacuum to say COVID shut my client. That was accurate. But the shutdown was not the reason he was unemployed. He was still working for that client and still involved in that client. He just wasn't receiving additional work from that client or additional paid work because it was this contingency fee agreement. There is not evidence to support the hearing panel's reasoning that, well, the shutdown foreclosed all chance of him getting regular paid work from the client, because what he was doing was work that would only be paid out if he collected the judgment.
Did the employer or did his client sell the business?
There is something in the record, I don't have a picture perfect memory of it, Justice Standridge, about the business had been sold, but he was still involved in the litigation.
So is there anything about whether he was providing any kind of services to the new client?
I do not recall that there is evidence to that. Obviously, if the record reflects differently than what I'm saying, I don't recall there being anything.
Okay, and then did the new client shut down because of COVID?
I think it is that business that had been his primary client was the one that shut down. I think that part is not fully fleshed out, to be honest with you. And so I don't know if the exact relation, it is just that the client he was doing the regular work for was shut down for COVID, but the reason he was not doing regular paid work was because of the contingency fee matter.
Given the ambiguities that you've just conceded in the last 3 questions, how is there clear and convincing evidence that he lied?
There's clear and convincing evidence because there is nothing in the record to support the only evidence in the record about the relationship with the client and what kind of work he was doing with the client at the time he applied for unemployment is the undisputed and stipulated evidence that he was working only on a contingency fee matter for that client.
But
And the finding that, I lost my word, I apologize. The finding that he was expecting more work is not supported by the record. And so the hearing panel essentially disregarded the existing stipulated evidence with an unsupported fact.
But you just said that the record is unclear about whether the new client would have hired him.
My recollection of the stipulation is that client, and I'm going to review the stipulation in this moment, is that client, and I don't know the exact details of the ownership, that client was the one that the contingency litigation, it became a contingency fee representation, and that is the client that was shut down by COVID. So I don't know that the issue of who owned the client, it is the same client.
But there is some evidence to support what he said happened, even if it's doesn't fill in all the dots and give all of the context as to what was going on with his client and what may have been ongoing with him.
Correct. But and again, our office is not saying that the statement that the client was shut down by COVID is inaccurate. It is saying that the reason he was unemployed was that shutdown is the inaccuracy, in context.
But they can be connected.
They could be connected, yes.
Okay, and I just want to make clear,
Yes.
for this singular isolated incident, you're asking that respondent's law license be indefinitely suspended.
I am about to run out of time and I'm concerned I will go over. May I answer this question?
You may.
Our office is not requesting for that isolated incident of that one statement. No. Our theory of the case and our allegation is that we are asking because of the pattern of dishonesty and the ongoing dishonesty throughout the life of the case. I have not been able to get into all of the other facts and all of the other allegations within our brief at this time because it is a factually complicated case. And there were a lot of facts contained in the final hearing report that we believe support that he committed multiple instances of dishonesty within this benefit period, and that the final hearing reports facts that they relied on to supplant the stipulation that they acknowledge and that they also find facts consistent with the stipulation are not supported by clear and convincing evidence. Nevertheless, it is the totality of the dishonesty in this case. The initial dishonesty stating that COVID-19 had shut his only client down and that is the reason he is unemployed. But even if this court were to find that clear and convincing evidence does not support that standing alone, his false information about his income, that he grossly overestimated or overrepresented the amount he made in 2019 that then the Department of Labor relied upon to start paying him benefits. And then his representation throughout the life of the case that he was neither working nor receiving compensation in self-employment when the undisputed evidence within the stipulation and within the exhibits demonstrate that he was working on many or receiving compensation on many of those weeks. Not every single one necessarily, but I believe exhibit 30 demonstrates that he worked 38 of the weeks during the benefit period, and with one exception, said he was not working. And so taken all together, and given
Well, he was working for no pay.
the forms do not differentiate between working and receiving income are within the same question, but they do not differentiate between the two when it comes to self-employment. There are also several weeks where he received compensation or actualized compensation, but did not report it as well.
Right. And then there was also a mix-up, which the panel found was, grounded in good faith about, the receipts that, when he estimated, that was receipts into the law firm, but didn't take into account any expenses and what his actual income would be, correct?
Are you referring to on the income form? Or are you referring to?
I'm referring to that he did an estimate of 120,000 and maybe it was close to that, but his income was only 38,000.
Yeah, so there is testimony that my recollection of the transcript is that Mr. Stewart didn't have a full memory of why he chose those numbers. He said he must have looked at his receipts and he, must have, based on that, made that determination that he recognized was no longer accurate. One of the things that our office briefed discussing both intentionality and pattern of misconduct is the fact that Mr. Stewart never, when he did fill out his taxes, attempted to correct that information with the Department of Labor. Eventually, he had to upload his tax returns to the Department of Labor. That happened shortly before the investigation process started with the Department of Labor in 2021. But nevertheless, and he describes that behavior as reckless and just doesn't have a great memory of that. As for to the extent that his sort of estimation and who received the money, because that did also come up at the hearing, and there was a discussion of, well, the money was paid into the law firm and Mr. Stewart was paid out of the money paid into the law firm. Mr. Stewart acknowledged that he would have actualized that money that came into his law firm, that compensation, at a time during the benefit period where it would have needed to be reported, and he didn't do so.
What does actualized mean? I don't understand.
When we discussed it in the hearing, actualized, I believe in our discussion was it would become your money for your purposes. He would have paid himself essentially.
Go ahead.
I have a specific question about restitution.
Yes.
It appears that there's an agreement that he was going to pay $45,000 plus a penalty.
Yes.
And the amount of the restitution, I believe that that the Department of Labor concluded retroactively that appropriate PUA weekly benefit to Mr. Stewart would have been $390 instead of the $488 that he actually received. My question is he paying in restitution the total amount that he received or the difference between what he could have received and what he did receive?
My recollection, and I will be happy to look up the stipulation regarding Mr. Stewart's repayment, because I'm not sure I have the details of that with me at the podium, Justice Wilson. My recollection is because of the finding of the Department of Labor, he is required to pay back all, this is in the original stipulation as well, he is required to pay back all benefits and the penalty, not simply the difference.
Right?
I have a couple questions if the chief
I'm
and the
done.
court will indulge me. Just a practical question. Isn't the problem of this case, doesn't all this arise because the Department of Labor's forms were created in a legal environment where self-employed persons couldn't apply? And then there was and if I'm wrong about this, correct me, but then there was congressional legislation which enabled self-employed people to apply, but he's using the old forms.
My understanding is these are forms made for the PUA program. All of the forms that are in the record say PUA questionnaire, and it has the self-employment question on it. So I cannot.
But, okay, fair enough. Do you know, or is it in the record, whether or not the Department of Labor just essentially copied and pasted the existing forms and then added a self-employment question on?
That is not in the record.
Okay.
I will note also that the forms for the PUA program have questions directly related to COVID as well.
Okay.
So they seem to, if not be related to, directly to self-employment, related to the pandemic and the special kind of assistance that is. I will also just note for the court that we stipulated, the parties jointly stipulated to many of the facts. And so some of those details that would have ordinarily come out regarding exactly how the program worked, the parties accepted that we were not going to
So
discuss that.
one legal question with respect to that. Was the respondent's law firm organized as a pass-through entity?
I apologize, a pass-through entity?
In other words, the income to the law firm passed through to the owner for tax purposes. It was not a corporation, in other words.
I believe it was an LLC.
And as a pass-through entity, maybe you don't know the answer to this question, I'm not sure I do. The income is income to the owner, all of the income. Is it not?
Justice Siegel, I will be honest with you that business associations is not my area of expertise. I don't know the answer to that. The testimony is that the money, in the way Mr. Stewart's business ran, was that the money came into the law firm, Stewart Law Firm LLC, then expenses
Right.
were removed.
As a legal matter, though, that's all his money. And the only question is how much of it is taxable? Because there are deductions for expenses on a pass-through entity, right?
I will agree with that to the extent I know, yes.
Okay, so I'll leave that behind. And my last question has to do specifically with paragraph 114 of the hearing report, which is where they find one violation of 8.4C.
Mhm.
And they find it on the grounds of negligent misrepresentation.
Yes.
So my question is negligent misrepresentation a thing under 8.4C?
Well, 8.4C recognizes misrepresentation.
Right, so it's a legal question as to what that means. And I guess I'll throw out a hypothetical. If I'm filling out an application for a home loan or whatever, and I round off my income, have I violated the rule?
It is a misrepresentation. So I would say yes, unless.
Is that right? I mean, do our rules require, I mean, is that what we're talking about here? Is if I round off my income, I don't include the cents, that I've now violated 8.4C?
It is not, that is not accurate information. And the rule itself, 8.4C, does not have a mindset, negligence or otherwise, imbued in it. But all of our cases are considered on a case-by-case basis, and
Do you have a case to cite to us where we have found a negligent act violates 8.4C?
I do not have one in front of me.
Okay, thank you.
Other questions?
If there are no other questions, I would simply request that this court find that Mr. Stewart committed multiple violations of 8.4C sufficient to find that his conduct was intentional, find that the aggravating factors outlined in the brief apply, and to adopt the Office of the Disciplinary Administrator's recommendation that he be indefinitely suspended. Thank you.
Mr. Ambrosio?
Madam Chief Justice, Your Honors, may it please the court. My brief covers everything that needs to be covered as far as the actual facts in this case. And a shout out to my summer law clerk, who's going to be our newest associate, Kinsey Bourdin, because I'm the worst writer in the history of the Western world, and my law clerks always wrote my briefs. Alcoholism in this case is what caused the problem for my client. He was drinking during this time when he filled out those applications, and during the time when he was receiving the money, from the time he got up in the morning until he passed out at night. Surely all of us know that that type of alcoholic use on a constant basis can lead to death. It can lead to mistakes. It can lead to infidelity. It can lead to all kinds of problems, including the problem that's visited upon us. I came into this case late, didn't represent him before the labor or anything else, only after the review panel found that there was probable cause to believe there was a violation and that it was set for hearing. And I looked at mitigation in this case as the most important thing, as are most of my cases before this court and panel's mitigation. And when I found out and listened to my client, who told me that now, when he came to my office, John, I've been clean and sober since November 26th of 2022. It should be almost 800 days soon. I knew that that was the problem in this case, and that is what we hit on. He is involved in Alcoholics Anonymous. He is leading groups. He is involved with KLAP on a constant basis, hopes to work for them, and hopes to be able to continue practicing law. I believe that the panel listened to the mitigation evidence. I don't believe that they tried to create what the result was to be because they liked what he had to say, but because they thought he should be given a second chance.
That wouldn't be proper, would it?
Sure, it's proper.
It wouldn't be proper for a panel to base its finding on rules violations by considering mitigating evidence. That would not be proper.
Well, they found a rule violation, Your Honor.
Right, but maybe I misunderstood what you said.
You probably didn't. But I always feel like I'm in the musical Chicago when I'm up here, so.
It sounded like you said that the mitigating evidence is what drove the findings.
It may have. I'm sure they found a way to use that to drive the findings. They thought the mistakes that he made.
May I ask a question? Are you finished? I'm sorry. Is there clear and convincing evidence to support the panel's findings?
That it was negligence? I believe so.
That there was a misrepresentation that was negligent because how he reported his 3019 income.
Yes.
I mean, there are findings here. Are the findings that are contested supported by clear and convincing evidence? It's my understanding that your client is the only one that presented evidence in addition to the stipulations that were considered by the panel.
That's correct.
So the panel considered both the evidence from your client and the panel's stipulations, and your stipulations as evidence, and made findings of fact. Are those findings of fact, including the ones that are contested, well, specifically the ones that are contested, supported by clear and convincing evidence from the hearing?
I believe they are supported on the issue that they found, that there was misstatements due to negligence as opposed to fraud, which is suggested here.
Well, they found on the other ones that there was not clear and convincing evidence of a violation. So are those findings also supported by clear and convincing evidence?
I believe so. I believe so. And I think this was driven by mitigation. And I hear what you're saying. I think they listened to my client and believed what he said, and believed because he was drunk all the time, dashed off these forms, didn't think about what he was doing, that he was negligent as opposed to involved in fraud.
Was there evidence that the forms were not particularly clear?
We talked about it. And the panel thought that they weren't clear because they discussed it in the panel report. I looked at the forms. I don't know what I would have done.
On that point, the forms just ask for income, right? Or was it?
They asked for income, but they also asked you to support with some documents also.
Right.
And if you read that report.
Can you answer my business association's question? This was a pass.
I was hoping you weren't going to ask me that. Just to say, I think it's a pass through. I really do. And I think you're right about that.
If I remember from my BA1 class in law school, like any income, the income is treated, there's no distinction between the entity and the owner. The income is to the law firm is the income to the owner.
That's the way I remember it, and I went to school.
Was there any discussion of that in the?
No, there was not.
Okay.
But he did stipulate working during many of the weeks. He received benefits when he worked on weeks where he submitted forms saying he did not work.
That's correct.
And that happened on multiple occasions.
That is
And he
correct.
stipulates to it.
Yes.
Was that compensable work?
And that's where we get into.
Or was it all
over here. That's where we
related
get
to
into
the
this.
contingent fee agreement?
He was working towards getting money under that judgment. And sooner or later, he hoped to receive money on one occasion he did. So he was working, but he wasn't getting paid for it. I want to get back to the mitigation because the mitigation is the most important part in this case. And this is why this cries out for a public censure as opposed to anything else. He has done everything that he's needed to do to be clean and sober. And I know I'm up here month after month after month arguing about alcoholism, depression, anxiety, drug abuse. And frankly, most of the people who are coming up here, if they aren't just plain thieves, and there are very few of those, have these problems when they carry them around on a constant basis. He is dealing with these issues and will deal with these issues for the rest of his life. And he's doing everything he can not to fall back again. And if you're reading the record, he was clean and sober for a long time. He dropped out of the church. And those of you who know me know I'm not very spiritual, but I admire the fact that he is spiritual, and that got him on the path to recovery. And his religion, his belief in a higher being, and his belief in the concepts of Al-Anon and Alcoholics Anonymous are what's making him live and what I think are saving him.
Can
But
I
he-
ask you a question about restitution?
The
The same question. So was there some that he could have received under the PUA?
Yes, Your Honor.
And he's paying that back also?
Yes. And as a matter of fact, by the way, last week, he paid the whole thing off. He worked his posterior off for 4 or 5 months, and he paid the entire $47,000 off last week. Because that was very important to him, but you're right about that. Without any further ado, I think it's important that my client address the court. I have your permission.
Just one quick question. Kind of they're not nuances, kind of the legal questions that my colleagues have asked about business associations, how we classify income. Was any of that put before the hearing panel? Was that argued by either side or?
It really wasn't.
Okay,
It really wasn't. and
so
maybe-
this is the first time this kind of
I didn't think of-
questions have been asked.
I didn't think about it until Justice Daigle raised it.
No, I just want to understand
You're
that
right.
that was
Absolutely.
not, okay.
You're right. You're right.
That's all I want to understand. Thank you.
Yes, if there are no other questions of you. Yes, please, Mr. Stewart.
Madam Chief Justice, Justices of the Court, may it please the Court. My name is Sean Stewart, and this has been an extraordinarily painful process, but one that was necessary. It was self-induced and self-inflicted. I'm thankful to God that He's a redeeming God, that He's a restoring God. And then He used an entire series of ill-advised choices and events in my life that really centered around my drinking to bring me to my knees and bring me back to Him. I'm so thankful to actually be standing here. I know it's a paradox. I've always dreamed of arguing in front of the Supreme Court, not in this case. But I'm thankful that I'm sober. As John's mentioned, I've been sober for nearly 800 days since November 26th of 2022. And it was on that day that I turned to my wife and I said, I have to stop this. I can't continue drinking. There were a series of things that were going on in my life. Everywhere I looked, I saw rubble, I saw ruin. And that was only from God. And so from that day forward, my wife and I have stopped drinking. And I've been battling this issue, this case. It was a week after I stopped drinking, thank God, that I received a letter from my wife. Opened up the mail. It was a letter about the complaint. And I'm thankful that I was sober when I got that letter. I had traded everything that I had loved and worked for, my family, for alcohol. It reigned and ruled my life. We talk about the statements of income. I guess I didn't care at the time. I stand before you today, a changed man. And it's because of what God has done and the people that He has used in my life to be here. Starting with my wife, who's here with me today. She's been with me since day one. She has stood by my side throughout this entire process. And I'm not a victim here. I'm not making excuses. I'm telling the truth. I'm stating what my life consisted of and what has happened to me and what I've gone through. And I'm thankful for John. John asked me about KLAP. I didn't even know who it was. I think maybe when I was in some CLE classes, I'd heard of KLAP and asked me if I was in AA. I had friends that were in AA. I had never reached out to them. So the first thing I did is drove to my friend Dan's business and told him about my story. And Dan said, we're going to Auburn tonight. We're going to Osage tomorrow to AA. And then John said, the first thing you're going to do is you're going to call KLAP. And I'm thankful for KLAP. I'm thankful for Bryn. What a tremendous asset KLAP and Bryn is to this court and to the community, to lawyers, those that are struggling with addiction, those that don't know they are. some of the best people in my life are the people I meet with every week at AA. God is doing some of his best work on this planet through people at AA. I've never seen more transformed lives in my life. And so I'm thankful for so many, my children. The level of support that I've received throughout this is indescribable from people in my house and people in my community. And I'm thankful. I'm very grateful for them. I'm grateful that God used all that I was going through for years to draw me back to him and to restore me. And I'm thankful for the gift of sobriety. And I will stand from the mountaintops and shout to the world about how awesome it is to be sober. Since November 26th of 2022, as difficult as this process has been, my life has never been this good. My business has never been this good. I'm thankful for the clients that have entrusted me to represent their incredibly important causes through transactions and litigation, pending litigation I have. I'm thankful for the ongoing work, the trial that I have coming up in April. I'm just thankful. I'm grateful. Sure, I wish it didn't have to come to standing here today and to go through this. But as one of my dear friends in AA says, it takes what it takes. And in closing, yesterday, when I had asked people to submit letters in support of me, I didn't ask them what to say. I said, I'm facing a very serious matter, and I read those letters, exhibits E through M. I read those yesterday, and I read words like integrity and honesty and character and accountability, and a man of God, a man that loves his family. A man who has admitted his wrongs, and a man who's sober. And as I read those letters, I recognize that guy. I recognize that Sean Stewart. That was a person, and in those letters, they're written from people that I've only known for a year, for 2 years, and then all the way from 10 years to 15 years, 20 years, 25, and 35 years. And they all wrote the same thing, and I didn't ask them to. And I look in the mirror this morning and right now, and I recognize that person, and I'm thankful that that's who stands before you today. And I believe the panel got it right. I believe that the discipline of censure is appropriate. I'm asking and praying that would be the discipline. In AA, we have 12 steps. I've went through those 12 steps in this case, literally. And one of those is to make amends with all those that you have wronged. I don't know how I could do anything more than what I've done to make amends in this case. As John mentioned, I paid all of the sums, some of which I was entitled to. I've paid all of every dollar back to the state of Kansas. I've admitted my wrongs. I've apologized. As I go forward every day, I think right, I try to do right, and I pray right. And I'm thankful that God's a God of a million second chances, and I'm asking that this court would give me a second chance, that my license would not be suspended, that there would be a censure, and that I would continue to be able to do what I thoroughly love. One of the most in my life is to practice law and to continue to represent my clients and to be a testament and an example to others that are struggling with this addiction, that there is hope, there's help, and that God's not through with them. I truly thank you for your time. I thank you for your service to the state of Kansas.
Thank you for letting me go over. That's part of his recovery. Thank you.
I want to address a handful of things that this court asked Mr. Ambrosio. I would note that to the question, Justice Rosen, about the first time things came up, because of the stipulation, there was not evidence or discussion until the hearing panel asked about the exact mechanism of how money came into Mr. Stewart's law firm about any of that. In the stipulation, Mr. Stewart admitted he received income on weeks that he said he did not. And he admitted to that at the hearing as well. There is a point, for instance, on page 57 of the transcript where he said there were weeks that I didn't work and didn't receive income, and there were weeks that I worked but didn't receive income, and there were weeks that I worked and received income. The same is true with the working. Mr. Stewart stipulated to and testified he completed work at times but said he did not. In terms of the forms and their clarity, the evidence in the record about forms being unclear is really about one form, that is Exhibit 7. It is the PUA application. Some of the check boxes, it was hard on the copy that is in the record to tell what was checked on there. However, when it comes to overall the clarity of the forms, there's no evidence either within the stipulation or within the testimony about those forms, to my recollection. I would just point out that, sorry, I can't read my own handwriting in this moment. I would point out that the amount Mr. Stewart repaid, Justice Wilson, that is through, he set that up through the Department of Labor, though it is within the Department of Labor's policies. That is not something our office, set that number or anything like that, just for the sake of the record. And I would note some of the evidence in the stipulation, additionally, including Mr. Stewart's statement that he was initially concerned about his law firm weathering the storm, but eventually was also trying to create a financial safety net for his family through this. Justice Stegall, I have been thinking about your question about rounding income. I will admit, when you said rounding income, I was imagining rounding up 82 to 90 or something like that. The preamble of the rules talks about them being rules of reason. And I also think it is important to note the preamble discusses, and our case law discusses, that lawyers are held to the rules even in conduct that is not directly related to their practice of law. And when we have here a situation where it is not rounding up 49 cents, but large amount, repeated instances of providing false information, and to an extent that results in a finding by the Department of Labor of fraud, that is a distinguishable situation. So unless the court has any other questions for me, I would thank you for your time this morning.
Thank you. Thank you to everyone for your statements and your arguments today. We'll take this matter under advisement. Call the final case on the morning docket of 127949 in the matter of James L. Daniel. Counsel.
May it please the court, Amanda Both on behalf of the Office of the Disciplinary Administrator's Office. Madam Chief Justice, I would request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
This is an original action in attorney discipline regarding the respondent, James Daniels, who has been licensed to practice law in the state of Kansas since 1993. I will first briefly talk about the procedural history of the case and then discuss the issues on appeal before talking more in depth about the recommended discipline. This case comes before you today following an evidentiary hearing that was held on January 4, 2024, which was bifurcated, and I'll talk about that here shortly, with the second hearing being held on June 10, 2024. The evidentiary hearing included a joint stipulation to some facts and exhibits. On January 4, the hearing panel found that Mr. Daniels violated 1.3 diligence and 1.4 A and B, both communication. At the January hearing, the ODA argued Mr. Daniels' probation plan was not workable, substantial, and detailed, and that he had not established that he had been complying with each condition in the probation plan for at least 14 days prior to the hearing, as is required by Rule 227. The ODA also stated that if the panel was inclined, it would not be opposed to the panel setting the case out and allowing Mr. Daniels to develop a more robust probation plan. We recommended a 180-day suspension, but we were not opposed to a 12-month probation period if Mr. Daniels could come back with a probation plan that complied with Rule 227. This case is somewhat unique in that the panel issued an order and did decide to give Mr. Daniels a second chance and held the record open from January until June. Mr. Daniels did then submit 2 additional probation plans. And at the June hearing, the ODA's position was that even with the additional 5 months that Mr. Daniels had, his plan still did not meet the requirements of Rule 227. The ODA recommended that he be suspended for 180 days. The hearing panel issued its final hearing report and recommended also that Mr. Daniels be suspended for 180 days, but said that 150 days of that could be suspended if Mr. Daniels submitted a probation plan that was approved by our office. Mr. Daniels filed exceptions, the ODA did not, and both parties briefed the case. Then on November 27, 2024, not quite a year after the initial hearing, Mr. Daniels filed the 4th probation plan, which is titled the 3rd revised. However, Mr. Daniels did not file an affidavit with the Supreme Court at least 14 days before oral argument regarding his 3rd revised probation plan, which is required under Rule 227F. So because Mr. Daniels continues to fail to comply with Rule 227, most recently with subsection F2, that today the ODA is still requesting the 180-day suspension.
So on the probation plan that was submitted in November,
Right.
that was not served 14 days prior to the Supreme Court?
So Rule 227F2 requires that an affidavit of compliance.
Oh, an
be
affidavit
filed.
of compliance?
Right.
Okay, so is there anything else wrong with the affidavit of compliance from November? Or is just the whole issue for you that, or the ODA's office, that he didn't comply with giving it to us 14 days in advance?
There was not an affidavit filed, as far as I have seen. There was a 4th amended, or there was a 4th probation plan, which is the 3rd revised, but there was not an affidavit of compliance. And then, so.
Okay, so yeah, that clarifies that for me. So on the 4th amended, which was titled the 3rd amended, or
Right.
whatever it is there anything that you take issue, or does the ODA's office take issue with in that probation plan if he were to have been complying with it?
Okay, so if he had filed the affidavit, as is required by the rule, then generally, no. Generally, I thought it was really good. I would say though, that in the 3rd revised probation plan from November 27, it says that, and I'm reading on page 7 on it, it says that he will meet with Attorney Truesdale on or before December 20, and then they will meet again on January 13. And on the bottom of that page, it says that written reports will be submitted to our office commencing on January 21. So what I did receive was something from Mr. Daniels a week late on January 28. And it said that they met on January 24, last Friday. So it doesn't appear that they met December 20 and January 13, as he said he would in the probation plan.
Okay, and then, and in that time period, what was the issue about the original person that was gonna be the supervisory attorney became unavailable for some reason, or?
Right, so initially, in the second plan that was filed in February, it listed an attorney, James Scott. And then so Mr. Scott, it's my understanding, was supposed to be supervising him February, March, April, part of May, and then on May 23, when they filed the third probation plan, which is the second amended, then
That was in May?
in May
Okay.
23rd, it said that he was no longer available.
Okay. And so did he identify a new person or not?
In the plan from November 27, he did, but that's the only thing I know about it, is what was in his probation plan filed November 27.
So as these processes happen in any case, where you've got proposed probation plans, there's this notion, and you even referenced it earlier, of the ODA's office approving a proposed probation plan, right?
That is what was in the final hearing report.
And am I right that that happens pretty regularly when you deal with probation plans?
I would say that does happen.
That there's an approval process?
I don't know that I would call it approval, but I mean, I do think that there are certain things that need to be in place. So I
Well,
mean, like,
Just help me understand how your office functions. This is a hypothetical case. There's a proposed probation plan. Like, how does the ODA communicate that it approves of the plan or that the plan is sufficient to move forward with?
in a normal case, that would be in the hearing. I mean, so there could be communication ahead of time saying, maybe you could consider doing this to beef up your
Okay.
probation plan, but
So is it unusual then for the hearing panel to talk about a plan that would come after the report?
so I don't have a lot of experience in that. So I am not sure.
I guess what I'm driving at is is there some practice that the ODA uses to communicate approval or disapproval of a plan?
I would say that it's probably case by case and person by person basis, but I
So it
mean,
could be just verbal, like there's no formalized way that the ODA issues a letter or
no.
a filing?
No, and normally it should all come out during the initial hearing. Like normally it would be decided at the initial hearing. So this case is kind of an outlier in that there was a second hearing, and then we do have this final hearing report that references the approval. But no, there's no actual process. It should all just be taken care of on the record, in the hearing, first hearing. So as to the first issue, which I will go through here quickly. The first issue that the ODA addressed was Mr. Daniels' challenge to the hearing panel's factual findings. And I'll just briefly talk about the facts that support the clear and convincing evidence. Mr. Daniels did not, well, okay, let me back up. KW suffered a fall on August 14, 2019. And then about 12 and a half months later, on September 1, KW and Mr. Daniels signed a contingent fee agreement. Mr. Daniels obtained a majority of the medical records from KW within a couple of months in November 2020. And then on August 13, 2021, Mr. Daniels filed a petition in the Shawnee County District Court. Mr. Daniels did not file a summons, and despite naming the defendants, the registered agents, and their addresses, he did not serve them. Mr. Daniels did not communicate to KW that he had filed the petition and did not send her a copy of the petition either before or after it was filed. He testified that he knew the status of the case, yet he did not check on the status of the case. And then on January 21, 2021, over 4 months after the case was filed, the court issued a notice stating that it would be dismissed if Mr. Daniels did not take further action to either prosecute the case or contact the court. Mr. Daniels did not do anything in the case, and he also did not communicate with KW regarding that notice. He neither told KW about the order nor that he failed to serve the defendants. And then over 2 weeks later, the court did dismiss the case. Mr. Daniels did know about the dismissal on that same date, but did not communicate that to KW. He testified that his plan was just to refile the case without talking to KW first. And he did not calendar a date in which it needed to be refiled. He also did not communicate to KW that he planned to refile the case, which deprived KW of having input in her own case. 5 weeks later, on February 11, KW emailed Mr. Daniels stating that she had phoned him many times with no response, and she inquired about the status. Mr. Daniels said that he would get back with her the following week. And on February 15, not having heard from Mr. Daniels, KW contacted the court and found out that her case had been dismissed. She testified that she was upset and felt bad because she did not know how to navigate the court, and that she had relied on Mr. Daniels to handle her case, and she no longer trusted Mr. Daniels. There was clear and convincing evidence that supported the hearing panel's findings. I will skip to, I have 1 minute left, so I'll skip to the issue about discipline. The hearing panel found that Mr. Daniels violated his duty to his client, that his mental state was that he engaged in a pattern of neglect and that caused injury to KW. And the hearing panel considered 4.42B and also 8.2 in finding that suspension was appropriate. The hearing panel also considered the aggravating and mitigating factors in this case. And one of the aggravating factors is the prior disciplinary history of Mr. Daniels. Despite Mr. Daniels saying throughout this case that his conduct was a mistake or a one-off, we know that he's been disciplined for similar misconduct in the past. He has been disciplined on 8 prior occasions, 7 times for 1.3 violations and 5 times for a 1.4 violation. That does include a 2007 suspension where he was suspended in Kansas for 1 year, then received reciprocal discipline in Missouri for 1 year. He was placed on probation and successfully completed probation in 2011.
Did you say that the suspension was supported by 4.42B? Is that the argument, suspension as opposed to other forms of discipline?
Yes.
And engages in a pattern of neglect and causes injury or potential injury to the client.
That's correct. That's what the hearing panel found. I would
Right.
submit that 4.42A is also supported by the facts, but the hearing panel did find 4.42B as the applicable mental state in this case.
How would you, I guess that you define the injury and not a timely prosecution, not in the loss of a claim. Is that how you would define injury in this context?
So the hearing panel found
Timely delivery of services, right? Or how would you define?
the hearing panel found that the injury was an unnecessary delay that resulted in a dismissal, and KW's inability to refile and KW's distrust of attorneys.
But they were allowed to I mean, she had the opportunity to refile. Is that correct?
So the testimony from KW was that before Mr. Daniels, the question was, will you take my case, essentially. But then after the dismissal and everything happened with Mr. Daniels, then it changed to, I'm not going to go behind. That was a testimony. I'm not going to go behind Mr. Daniels. So it changed more to attorneys viewed it more as a malpractice rather than, can we file your slip and fall? So I think that is where that's why the hearing panel found that she lost her ability to file, because the issue changed after the representation.
What? How did the issue change?
So my understanding from the testimony was that initially KW would go and ask an attorney, will you take my slip and fall case? So after Mr. Daniels didn't serve the defendants and it was dismissed, then when she talked to an attorney, was her testimony is that they said they didn't want to go behind him. Go behind him? What does that mean? My interpretation is that it was more of a malpractice issue. Like they didn't want to go behind what a different attorney had done and or messed up in a case.
She was seeking services of a new counsel to pursue a malpractice claim rather than to refile her original
Oh, is
personal
that what you-
injury? Is
I
that
think-
what you're?
My understanding is that she was trying to get someone to still take the slip and fall, but that is not how attorneys viewed it at that, like anymore, after the representation and after it was dismissed.
Okay, I don't really follow that. I have a question. Okay, so on this suspension that what the panel recommended 180-day suspension with 150 of it stayed. And was there probation in that too?
They said 150 days of it being stayed if Mr. Daniels would submit a probation plan approved by the ODA.
Okay, and so and what's the ODA's position?
So the ODA's position is that because Mr. Daniels did not file an affidavit that is required, it says that a 227F says that a respondent who seeks to be placed on probation at least 14 days before oral argument must complete the following. And then 2A says file with the Supreme
Right.
Court.
Okay.
So,
got that.
okay.
Okay, so my bottom line is, what's the difference between 180 days with 150 days suspended and 180 days with 180 days suspended? I mean, that 30 days seems pretty darn significant, because when you're suspended like that, okay, and you don't get probation, you have to notify all your clients. All your clients have to find new counsel. I mean, it is a huge disruption that affects not only Mr. Daniels, but also all of his clients and the courts that are hearing the cases, because then they're going to have to give continuances. And I just don't understand the reasoning of, I don't get that.
The hearing panel's reasoning?
Or yours, because that's kind of where you are too.
Well, so the ODA is still staying with the 180-day recommendation because 227 has not been complied with. So the hearing panel.
But you said at the beginning that if he submits one, then didn't you say that? Wasn't that your opening?
I don't.
Okay, so at this point, he can't cure it, you're saying? He can't cure it today.
Right. I mean, it was not complied, like Rule 227F was not complied with, and it's a must under the rule. And so because of that, I don't think that probation is an option. And
the reason that it's not working is because, number one, he had this, as I look at it, first evidentiary hearings, January 2024. In February 2024, he says, James Scott's going to be my guy. In May 2024, James Scott's no longer my guy, but he didn't identify anybody. But the second hearing hadn't even taken place by then, so he had no idea. And then in June 2024, the continued hearing took place. They issued their ruling in July of 2024. And then in November 2024, he submits this new and identifies the new supervising attorney. But your issue is, then he didn't meet with that attorney in December like he said he was gonna. And then he met with that attorney a week late in January, and he didn't file the affidavits. So that's the difference between closing your whole practice. It's because of that, right?
our position is that he has not complied with Rule 227 throughout the proceedings, including most recently Rule 227F. And so even if he had complied with Rule 227F, there was, he didn't meet with his probation supervisor until a month after he said he would. He didn't submit the report when he said he would. So even if we don't have
the report, you mean the affidavit of compliance?
Well, that either. I'm talking about the report that he said he would submit on January 21 to our office, but submitted it a couple of days ago instead.
What report is that?
It's the one that it says respondent will be responsible for documenting the dates duration, substance of each conference, and will submit written reports to the ODA at least once every 60 days commencing January 21. So I'm saying, even if we put aside the requirement of Rule 227F, then there are still issues that he's not, I mean, it's a too little too late, which has happened throughout the case. And the most recent too little too late was the Rule 227. And also, I mean, even what he says he's going to do in the most recent probation plan, he didn't do.
Okay, if the chief may indulge me with one more question, and that is on the issue of, oh, no, I forgot the question. Sorry. Sorry, chief.
It's fine. Any others?
Okay.
Thank you.
Thank you.
I remembered it was then.
Don't take it personally.
May it please the court.
Yes, please.
Keith Cutler on behalf of the respondent, James Daniels. Let me start by saying that Mr. Daniels acknowledges that he has made some mistakes in this case. He should have gotten the defendants in the case served, and he didn't do that. He should have seen the email that ultimately led to the client's case being dismissed without prejudice. He should have seen that. He takes full responsibility for that and for his mistakes. But that's not why we're really here. Why we're here is because the punishment recommended by the hearing panel does not fit the conduct involved in this case. In cases where attorney's conduct has been similar and in some instances even identical to Mr. Daniels' conduct, this court has imposed much lighter discipline than what the hearing panel is recommending and what ODA is recommending. Now, Mr. Daniels recognizes that this court is not bound by its decision in other cases about prior discipline.
In the other cases you're referencing, did the respondent in those cases have the history of discipline that your client has?
Yes, as I recall from those cases, there was none of those cases was this their first appearance with the disciplinary matter. But however,
But we got 8. It's not just, that they had something before. We've got a real history here.
we have a history, but that history is more than 20 years old. And in the cases that this court has handled, which we cited in our brief, in those cases being the In re Ketter, In re Sutton, In re Pistotnik, where the conduct involved was 11 years prior, 7 years prior, 5 years prior. This court said those cases are too remote to be considered in the imposition of discipline stage. Mr. Daniels' conduct goes back 20 or more years, even to the 90s. That's the conduct that the hearing panel relied on in making his recommendation to this court, and that was wrong based on this court's prior decisions.
And let me just clarify that that the panel used this not just as a, when they were considering it as an aggravating factor, they considered it not as just prior, but that as a pattern and practice, right?
Yes.
Okay. And so then from 2007 until, when did this happen? 2022 or what?
Correct.
So they didn't consider the fact that, of that, as far as pattern and practice, this giant gap in the pattern and practice.
Absolutely. They did not consider that. And let me be clear about the 2007 date. There was discipline that occurred reciprocally in Missouri. And so the conduct behind the 2003, 2006, 2007 discipline was conduct from 2003, 2004. So it wasn't conduct that was going all the way up to 2007. We are talking about conduct that was 20 years old, that they skipped over that entire 20-year period of no complaints, no discipline, or no new discipline complaints. Skipped over all of that to try to establish a pattern of conduct from 20 years before. The other thing they did to try to establish a pattern of conduct is they called Mr. Daniels out on a number of things, as you read in the hearing report, that are not violations of the rules of professional conduct. They called him out for filing the petition on the day before the statute ran. That's not a violation of the rules to file a lawsuit within the statute. And especially in this case, when Mr. Daniels got the case, more than half the limitations period had already run. He only had 11 months and he filed it within that time period, yet they dinged him for that. And that's not a violation of the rules of professional conduct. They called him out because they said he did not send a copy of the petition to his client for approval before he filed it. That's not required by the rules. And most attorneys don't do that, but yet they dinged him on that. They said that he never met with his client in person, completely ignoring the fact that the client lived in Topeka. Mr. Daniels' office is in Kansas City, Missouri, 70 miles away. This is a 65-year-old woman, and this all was happening in the aftermath of COVID. So of course, it made sense to conduct all of their business via telephone and via email. Yet they dinged him for not ever having met his client in person when that's not a violation of the rules. They called him out for not contacting the insurance company in the case. Well, there was already a letter, which is part of the record, that shows the insurance company denied liability. They weren't going to pay. There's nothing in the rules that requires you to beat that dead horse. They've already said they're not going to pay. Let's just move on with the lawsuit. They dinged him for that. So in addition to reaching over that huge 20-year gap of compliance with the rules to try to establish a pattern of conduct, they even reached outside of the rules of professional conduct to try to establish a pattern of conduct to support the ultimately and unduly harsh penalty that they're proposing of not only suspension, but suspension with only 150 days of the 180 days stayed.
What do you think what is your recommendation?
Respondent's
terms of just-
recommendation for discipline is a public censure. That is appropriate under the circumstances. It fits the guidelines, the ABA guidelines, and it's also consistent with this court's other decisions with similar conduct that we cited in Ray Bolton, in Ray Davison, in Ray Wiles. At most, maybe an admonition.
Do you agree that probation is off the table here because of the failure to comply with the rules?
I don't, because as Ms. Voth mentioned, there really is not a formal process for the ODA's approval. If there was an affidavit missing, again, this was filed back in November. If there was an affidavit missing, she could have sent me an email saying, hey, where's your Rule 227F affidavit?
Well, do you agree that there was no affidavit filed?
Correct, there was no affidavit filed.
Okay.
And there were no updates filed, at least timely updates about the supervision and what's going on in the case that was part of the plan?
I'm not sure I understand the question, but I can tell you that a report was submitted. Yes, it was late.
I guess that's my question, that it wasn't a timely report. It was late and pretty much contemporaneous with this hearing today, when it just a couple days ago.
Yes, well, it was a week late. So the initial deadline to begin with would have been just days before this hearing. So it was just a week late. With respect to the practice supervisor, and I think this is fully set out in the briefs, the reason the initial practice supervisor was unable to continue was because he had a family emergency with his son, and he contacted Mr. Daniels just days before the probation plan was due to say, I'm not going to be able to do this. So this just isn't a situation where we had a practice supervisor and then now we got to find somebody else. This was an emergency beyond Mr. Daniels' control that necessitated him to try to find another practice supervisor. I think in our brief, we mentioned he's contacted 5 or 6 attorneys to try to help him out with this. So he's not sitting on his hands. He's not just blowing off this obligation. He has been really trying to comply with the requirement for a practice supervisor and not necessarily excusing the fact that the reports were late, but he's trying the best he can. The third thing I'd like to note for the court is that, as Judge Standers pointed out, the panel's recommendation that only 5 months of the suspension be stayed is just unnecessarily punitive under the circumstances. This is a case involving a negligent oversight. There was no dishonesty. There was no intent. There's no theft of client funds, no selfish motive. The client did not lose her cause of action. He gave her a ready-made petition that she could either file herself or get an attorney to file. So there was no harm to the client. Inasmuch as Mr. Daniels has not had any complaints in the last 20 years, this is not a situation where the public needs to be protected from him. And this court should be aware, as Justice Standers adequately pointed out, him being required to shut down his practice for a month will have a deleterious effect on the constitutional rights of his criminal clients and would require the rescheduling and reshuffling of the cases for his civil clients, not just with them, but with opposing counsel and with the courts. It would also have a devastating effect on Mr. Daniels' family and livelihood. The detrimental effect of shutting down his practice for a month is not just going to magically go away on the 31st day. The impact of him shutting down his practice and having to notify everybody, not being able to pay his staff, that will have a long-lasting effect, many, many, many months beyond just that 30 days. I will conclude by saying that the purpose, as this court knows, of attorney discipline is not to punish the attorney, but to maintain appropriate standards of professional conduct for the protection of the public and the maintenance of public confidence in the bar. Suspending Mr. Daniels and shutting down his practice for 30 days is clearly punitive in nature and is markedly inconsistent with the discipline that this court has imposed in similar cases, such as the Bowden case, Davison case, and Wiles. Mr. Daniels has admitted he's made some mistakes. He's cooperated in every step of the way in this proceeding. He's implemented the corrective procedures in the plan, and they've actually really helped his practice. He's going to talk to you in a minute with the court's permission about how it's really helped his practice and improved the way he does things, his communications with clients, which is what we want from attorneys. We want them to improve what they're doing. We don't want to knock them over the head and kick them when they can improve and make the improvements that he's made. He has found a replacement practice supervisor who he's been talking with, he's met with. He's on the path that we want him to be on to make sure we don't have incidents like this again. And so based on all of the attendant facts and all the circumstances and the law, as this court has pronounced in other cases, we think that a public censure is the correct punishment in this case, or at most an admonition. Would ask if the court is inclined to impose a suspension, that the stay be imposed for the entire period of suspension, not just a portion of it. And so if it pleases the court, Mr. Daniels would like to address the court at this time.
Certainly. Mr. Daniels.
Good afternoon, Your Honors. My name is James Daniels, and obviously I am the respondent in this case. I operate a law firm in Kansas City, Missouri, and I specialize in personal injury cases and criminal cases. I'm available to my clients in person, by telephone, by Zoom, by text, and many of them have my cell phone. This case that we're discussing today came to me in September of 2020. Obviously, the height of the COVID pandemic a time when all of us were dealing with some very unusual challenges. This client came to me essentially pleading that I take her case because no one else would take it. It was not a good case. It's a trip and fall case with no surgery, no bills, in a conservative venue. The reason she told me that lawyers were telling her they did not want to take the case was these Kansas laws. It's a trip and fall case. It's the 6258, the comparative fault statute, in which provides that if that plaintiff is 50% at fault, there's no recovery. That was my interpretation of what the lawyers meant when they were telling her these Kansas laws are the reason they did not want her case. It was a bad case. Nevertheless, I took it. When you take a case, the standard is the standard. I did not meet the standard. I didn't get the defendant served, and I missed the email. The standard is the standard. I didn't meet it, and I'm sorry for any inconvenience or undue stress that was caused to this client by this this activity or the failure to get the defendant served. So we know what the allegations are and what the problems were in this case. So if the court is pleased, I will tell you what I've done to correct the problems. With regard to deadlines, and to answer your question, Your Honor, about the DA being made aware of what I was doing, this was everything that I'm about to tell you now was part of the testimony at one of these hearings we had. They suggested I get practice management software, which I did. The software is called Clio. The practice management software has ticklers that will kick out deadlines. When I file a lawsuit, I put in that tickler for statute of limitations, 180 days. It's 180, 120, 90, 60, 45, 30, 15, 10, 7, and 1. So from 6 months before any statute runs, I'm getting a tickler every. Then with regard to service of process, it's every 90 days. It starts at 90, 90, 60, 45, 30, 15, 10, 7, 1. So I have put that in place. I filed 4 lawsuits since this case came about, and I've obtained service in every one of them in a timely manner, usually within days, because now when I file a lawsuit in Kansas, I file the summons at the same time. So when the stamp comes back, as soon as the clerk stamps the summons, the lawsuit goes out. So with regard to emails from the court communications, any court communications that come to me now come to 3 separate emails. They come to my firm email, they come to my personal email, and they go to my assistant's email. So everybody, there's emails, 3 different emails that anything that comes from the court is going to go to. So that's what I've done in terms of trying to ensure that I don't overlook any correspondence from the court. So with regard to, the practice managers, I think Justice Stiegel was kind of touched on this. With Mr. Scott, he had an emergency, and so I didn't want to burden him with all of these meetings and taking up all of his time before not even knowing whether this probation plan was going to be approved or not. They made the suggestions. I went out to put these measures in place to alleviate the problems. The probation plan sets out certain intervals, minimal intervals to which I'm supposed to contact clients. If it's a criminal client, it's every 30 days at least. But with criminal cases, they move pretty rapidly. There's hardly gonna be a 30-day time period when something is not happening. When I leave this courthouse today, I'm going to Geary County to meet an incarcerated client. With regard to civil clients, it's every 60 days because they can slow down. But still, I haven't had an instance yet in a case where there was not some communication in a shorter period of time. In this particular case, the client testified that she had at least 16 or 17 telephone calls with my office. Whether that was with me or my assistant, the communications occurred. When she reached out to me by email, as the record reflects, and you guys have read the briefs, the communication was immediately forthcoming. There's no communications issue in this case, and I generally try to not allow that to happen. So I missed the deadline. I missed the service process deadline. There's no doubt about it. But I put the measures in place to ensure that it doesn't happen again. And I'm hoping that the court will see, the value in that, and also see that in similar cases that this court has handed down, there has been no suspension in cases like this. There's been no suspension in cases like this. There's no dishonesty. There's no money involved. This client had plenty of time to refile her lawsuit. She chose to, but she didn't do that. She chose to go look for a malpractice lawyer who apparently didn't, and that is the person who guided her toward the bar complaint. When she started contacting me, I could tell she already had another lawyer. So that's why I said, hey, here's the complaint, the petition, it's in Word format. Your lawyer can change it or you can file it pro se. But I knew she had another lawyer. But the purpose of her going to another lawyer was to, and that was before the case was even, before she even knew the case was dismissed. I'm not sure, what was going on there. But in any event, the other thing that I do with regard, so that doesn't happen, with regard to petitions, when I file a lawsuit, I send the client a letter that says, please find and close the petition filed on your behalf on this date. So they have the petition once I file it. So I think I've tried to address every issue that the disciplinary administrator has raised in this case, the communications issues, the diligence issue, even things that aren't required, like sending that petition out to the clients. I've done everything except comply with Rule 27's stipulations of filing the affidavit. She received a report from me yesterday about my meeting with Mr. Truesdale on the 28th. She also received a letter from Mr. Truesdale. So she knows that all of that is in place. The technicalities of the Rule 227 I didn't comply with. But based on prior precedent set forth by this court, probation is not even an appropriate sanction in this case. But if the court decides that it is, I will cure, I don't know if there's a mechanism to cure those issues, but the DA did not even she did not argue that the plan wasn't workable, that it didn't have the appropriate measures in place. That's not the argument. The argument is on the technicality, you should be suspended because you didn't comply with sending the affidavit and you didn't do these things on time. That's not justice. That's retribution. In any event, I believe I've made all the points I came here to make today. Unless the court has questions, I'm very happy and very open to answer any questions you may have.
I see none. Thank you, Mr. Daniels.
Thank you, Chief.
Ms. Foe?
There are three things that I'd like to quickly address. First, the ODA's argument the entire time that this case has been going on since the first proceeding, second hearing, and now is that he has not complied with Rule 227. There are different subsections that he hasn't complied with, But that is not something that is new today. It
Can
has
can I,
always been.
on that point,
Yes.
I understand the argument about the failure to comply while the hearing panel was active. As I read 227, there's no provision at all for probation to be considered, to be initiated after the hearing report's filed.
Correct.
So whatever happened after this, all the November proposed plan and the like, there's no provision in the rule for any of that, is there?
There's not.
Okay, should we hold, are you asking us to hold the failure to comply with 227 post-hearing report against the respondent? When
So-
that doesn't even exist, right?
Well, so, okay, so you're saying that 227F though still requires that if a respondent is seeking probation, that he or she files
But
an
that
affidavit.
that references the plan that is filed and proposed 14 days before the hearing.
Right.
That's not what we have here.
No, that is true.
So I guess I'm just wondering, it seems as though this is sort of an ad hoc thing that is not governed by any rule.
I would agree.
There's no
with that.
provision in the rules for this.
There's not, right, there aren't
I would
provisions.
maybe suggest that whatever happened with this third or fourth probation plan is kind of irrelevant.
I would agree.
Okay.
Real quickly, there was some discussion about the hearing panel's finding of one aggravating factor of that being a pattern of misconduct. And I just wanted to quickly touch on that to say that they mentioned briefly, not only has Mr. Daniels repeatedly engaged in misconduct involving lack of diligence in communications, but continually did that throughout this case as well. And they cited specific instances of that. So it was their pattern of misconduct was not only based on their prior disciplinary history. The last thing I wanted to touch on was a case that has been more recently decided. I know Mr. Cutler has cited to some cases from 1988 and 2003, I think is the most recent one. But there was a case that's in Re Stewart, and that was about 13 months ago. It's from December 29 of 2023, where this court did impose a suspension for 1.1, 1.3, and 1.4 violations. And in that case, it's a little bit different because the probation officer testified, and so he got probation, but he received an underlying suspension term. If there aren't questions, then I'm out of time.
See no question. Okay, thank you. Thank you to all of you for your statements and your arguments today. The court will take this matter under advisement. The court is now adjourned.